Let's take a look at the Fair Labor Standards Act. The Fair Labor Standards Act, known as the FLSA, establishes a federal minimum wage and requires premium pay for overtime work. It also sets out certain work hour limitations for minors. The FLSA's main requirements are straightforward. The law's complexity derives from problems in applying its general provisions to the many forms that compensation takes and to difficulties in counting hours of work. Analysis of wage and hour issues is further complicated by the existence of many exceptions, exemptions, to the FLSA's general requirements. Under the FLSA, employers must pay employees at a rate no less than the minimum wage for each hour worked during a work week. The federal minimum wage was increased to $7.25 per hour in July of 2009 and will remain at that level until such time as Congress decides to change it. Many states and some cities, however, have established minimum wage rates well in excess of the federal minimum wage. For the majority of employees, it is the state and local law that define their minimum rate of pay. Though it is stated as an hourly rate, other rates can also be used, like weekly pay. It just means that when the amount paid for each work week is converted to an hourly rate, that rate must be equal or greater than the minimum wage. Nor does the FLSA specify any particular pay period. Payment of the minimum wage and overtime must be prompt, but that generally means in the paycheck covering the relevant work week. The federal government itself missed this requirement when, during a partial government shutdown in 2013, employees were paid 2 weeks late rather than on their regularly scheduled payday. To determine whether the minimum wage has been paid, total straight time, not including overtime pay for a work week, is divided by total hours worked during that work week. A significant exception to the general requirement of hourly pay at least equal to the minimum wage is made for tipped employees, defined as employees who customarily and regularly receive at least $30 per month in tips. Under the FLSA, employers can meet their minimum wage obligation to tipped employees by paying them at least $2.13 per hour, provided that this amount plus tips equals at least the minimum wage. However, to take advantage of the tip credit, employers must inform employees about it beforehand and allow employees to retain all tips, either individually or pooled among employees. Employers are also permitted to deduct from tips the transaction fees charged by credit card issuers when tips are paid using credit cards. The minimum wage requirement applies to gross pay. Employers are required to withhold income taxes from employees' gross pay, as well as the employee's share of Social Security and Medicare. With employees' consent, deductions can be made for items such as insurance, union dues, and savings plans. Additional sums may be deducted because a court or government agency has ordered an employee's pay to be garnished to recover money owed for obligations such as child support, alimony, and student loans. Employers are not free to charge employees for items that primarily benefit the employer, like uniforms, when the effect of those deductions would be to push an employee's hourly rate below the minimum wage. Laws in some states prohibit such deductions outright. Under the FLSA, employers must pay at least 1.5 times an employee's regular rate of pay for each hour worked in excess of 40 hours in a work week. Other than for minors, the FLSA does not limit the number of hours employees can be required to work. Instead, the Act gives employers a financial incentive to limit overtime because those hours of work must be compensated at a premium. That premium is expressed in terms of an employee's regular rate of pay. If an employee is paid an hourly wage, the hourly wage is the regular rate, barring receipt of certain other payments. However, if the employee is paid a weekly salary or a fluctuating number of hours, the regular rate would be the weekly salary divided by the number of hours actually worked in each work week. Computing the regular rate in this manner is nonetheless legal, although a potential labor relations nightmare. provided that the employer previously informed the employee that overtime pay would be calculated in this manner. The basic unit of time for determining compliance with both the FLSA's minimum wage and overtime requirements is the workweek. The workweek is any fixed period that's recurring in terms of 7 consecutive days or 168 hours. The workweek does not necessarily correspond to the calendar week or begin at the start of a workday. Work does not necessarily occur on every day of the work week. With just a few exceptions, FLSA overtime is earned on a weekly basis. It does not matter how many hours an employee works on a particular day. The relevant issue is the number of hours worked in the work week. However, daily overtime might be required under a collective bargaining agreement or state law. Just as there's no daily overtime under the FLSA, hours of work generally cannot be averaged across work weeks. As an example, a long work week followed by a short one to avoid overtime liability. However, employers can rearrange hours within work weeks to avoid incurring overtime liability. What if an employee who has been working long hours were to prefer more time off instead of overtime pay? The legality of comp time, that is, paying for overtime work with compensatory time off rather than overtime pay, depends on whether the employer is in the private or public sector. Private employers cannot pay for overtime required under the FLSA with compensatory time off in the future, whereas government agencies can. The explanation for this difference is essentially that public employers were not originally covered by the FLSA, and Congress seized upon comp time as a means for softening the fiscal impact when public employers became subject to the law. The ability of public employers to provide comp time in lieu of cash payment for overtime work is subject to certain standards. First, it must be in accordance with an agreement to that effect, either with individual employees or with their collective bargaining representative when the public employees are unionized. For most public employees, the maximum amount of comp time that can be banked is capped at 240 hours. Any additional overtime must be paid in cash. Public employees have the right to use their accrued comp time within a reasonable period after making that request, but not in taking the compensatory time off would unduly disrupt operations of the public agency. The right to use comp time with a reasonable period does not require that the public employer provide time off for the specific days requested, as long as it's provided within a reasonable amount of time. Public employers are also allowed to cash out employees' accrued comp time if they so choose, and employees terminating are entitled to be paid for their unused comp time. Compensation takes on many forms. Employees receive not only hourly wages or salaries, but also tips, commissions, piecework earnings, bonuses, and merit pay. Lodging and meals, pay for holidays, vacations and sick days, premium pay for working on weekends or night shifts, and profit sharing and benefits are among other forms of payment for work. Although wages must generally be paid in cash, including a paycheck or direct deposit, the cost of goods provided by employers, such as lodging and meals, can be credited against minimum wage and overtime obligation. Many employers pay hourly employees by issuing payroll cards, which does not violate the FLSA. However, in response to complaints about fees incurred by employees using the cards, some states have stepped in to regulate their use. Depending on the types of compensation that are considered, some of which may be occasional bonuses or may be attached to work performed, paid sick days, an employee's regular rate of pay might vary substantially. When calculating the regular rate of pay on which overtime is based, most forms of compensation must be included. The primary exclusions are the following: most paid absences like vacation, holiday, or illness, discretionary bonuses not based on merit or attendance and prizes, and reimbursement for expenses like travel. Employer payment for pensions and benefits, profit sharing plans, many forms of premium pay like extra pay for working on holidays, daily or other non-FLSA required overtime pay. In one case, the city of Albuquerque erred by failing to include compensation for unused sick leave buybacks in the regular rate of pay. Even though paid sick days can be excluded, the court ruled that buybacks are more like performance-based bonuses for good attendance and must be included when calculating overtime pay. Not surprisingly, the FLSA contains substantial record-keeping requirements in terms of payments to workers for their hours worked. Records of wages paid and hours worked must be kept for at least 3 years. Inadequate record keeping is a violation in itself, and in the absence of employer documentations, courts will accept employees' reasonable estimates of what they're owed. Besides compensation received, the number of hours worked in a work week must be known to determine compliance with the FLSA. This can be more complicated than simply consulting timesheets. Questions about compensable time arise because the workday is often punctuated with breaks, periods of downtime, and other activities different from work duties. Conversely, work duties sometimes intrude on time off. It's not always obvious when the workday begins and ends. There are a few basic principles for determining whether activities are compensable. A starting point is that employers are required to compensate all work that they suffer or permit. Claims that employees have contributed work without employers' knowledge and against their will are rightly viewed with skepticism. This does not mean that employers are expected to be aware of everything that employees do, or that employees can simply perform work anywhere or at any time and present their employers with the bill. Thus, employers are well advised to establish clear procedures for employees to report and request pay for extra work performed. If employers do not want their employees to work extra hours in the first place, they must communicate and enforce policies prohibiting employees from working outside of assigned work hours without prior authorization. For these policies to be genuine, supervisors cannot ignore workers starting work early, staying late, or continuing or coming in on scheduled days off. Nor should employees be assigned work and given deadlines that effectively require them to work late or take work home. Similarly, employees should not be pressured or allowed to underreport hours worked. The amount of time actually spent performing work duties determines compensable time. Taking too long to carry out a task might need to be addressed as a performance issue, but it is not an excuse for withholding pay from an employee. Many questions about compensable time hinge on whether the time in question was or was not spent predominantly for the benefit of the employee. Break periods during the workday might or might not be compensable depending on their length. Meal periods, 30 minutes or longer, are generally not compensable provided that employees are substantially relieved of their work duty. Break periods of 20 minutes or less are seen as serving the employer's purposes, like safety and productivity, and as not being sufficiently long to predominantly benefit employees. The more restrictions, work-related duties, and interruptions that are present, the more likely it is that breaks will be compensable. Situations in which employees are required to remain on call raise the same issue. Another principle used by the courts is that activities must be sufficiently related to employees' primary job duties to be deemed compensable. Time spent performing activities that are clearly preliminary or postliminary in the employee's main activities are not compensable unless made so by contract, custom, or practice. Time spent commuting to and from work, clocking in, and walking to the location at which work tasks are performed is usually not compensable. What about time spent putting on, donning, and taking off, doffing, protective clothing, and safety equipment? Such time is compensable when these activities are required by the nature of the job and not merely matters of personal preference. Employers are exempted or excused from having to follow some or all of the FLSA's rules for certain types of employees. Some of these are full exemptions and can be completely disregarded for exempt employees. Other exemptions are partial where something other than the general rule applies to exempt employees. Employers do not have to follow FLSA requirements for exempt employees, but non-exempt employees are entitled to the Act's protections. The most significant FLSA exemptions are for executive, administrative, and professional employees. These occupations are found in all types of businesses and account for an estimated 20 to 27% of the full-time U.S. workforce. Employees holding these jobs often work long hours and earn relatively high rates of pay. That so-called white-collar exemption frees employers from the obligation to pay overtime to these employees, and it's no small matter. But who is exempt executive, administrative, or professional employees? Employers tend to take a broad view of which employees fit under the umbrella of white-collar exemption, whereas employees are likely to claim that they are non-exempt and entitled to overtime pay. In the face of legal challenges, employers bear the burden of proving that employees denied the Act's protections are in fact exempt. A common misconception is that whether an employee is exempt turns solely on whether that employee is paid a salary. That's not true, or at best, it's incomplete. To determine whether an individual is exempt, the nature of that individual's duties and responsibilities must be closely examined. This is known as the duties test, as well as the manner in which the person is paid, which is known as the salary basis test. Not everyone paid a salary is an exempt employee. Exempt status rests in part on applying a duties test to determine whether employees' duties are genuinely executive, administrative, or professional in nature. Job titles by themselves mean nothing. Calling a secretary an administrative assistant 1 does not transform that person into an exempt employee. The burden on employers to establish exempt status provides yet another reason to maintain accurate and up-to-date job descriptions. An employee's job description should clearly support the determination of exempt status. The same occupation can be exempt or non-exempt depending on particular circumstances. For employees who analyze customer financial information or provide advice on which financial products best meet their needs, DOL regulations generally suggest that these employees should be exempt. However, if the individual's primary duty is selling financial products, she will not be deemed an exempt administrative employee. Jobs frequently entail a mixture of exempt and non-exempt activities. Courts have to determine whether the primary duties of an employee are exempt in nature. Although exempt work normally consumes more than half of an exempt employee's work time, the primary duties of the employee are not necessarily those performed most regularly. Other factors to consider include the importance of the exempt duties, the employee's relative freedom from direct supervision, and the employee's salary compared to wages paid for non-exempt work. Correctly identifying administrative employees poses particular problems. Merely performing office work or brushing shoulders with managers is not enough to confer exempt status. The fundamental criterion is whether the individual performs primarily office or non-manual duties that relate to the general operations and policies of the organization, as opposed to producing the goods or services that it sells. Another important criteria for distinguishing administrative from clerical employees is the exercise of discretion and independent judgment with respect to matters of significance. To exercise discretion and independent judgment, an employee must have the authority to consider possible courses of action and make independent choices about significant matters. To be exempt, executive, administrative, and professional employees must also be paid salaries. Employees must be paid at least $455 per week to qualify for any of the white-collar exemptions. Pay of more than $100,000 per year creates a presumption of exempt status. At this minimum salary level, an employee who earns as little as $23,660 per year could still be exempt. In 2016, the DOL attempted to increase the minimum salary level required to be exempt to $913 per week. Some business organizations and state governments challenged the new regulation, and a district court eventually ruled that the DOL had exceeded its authority by increasing the minimum salary level so substantially. Salary level is not the only relevant consideration. Sometimes a question arises about whether the method of payment, regardless of the amount, is truly a salary. A salary can be contrasted with an hourly wage, in which pay is closely calibrated to the time put in, or with a piece rate system in which pay is directly based on the volume of output. A salary is a pre-specified sum that an employee is paid for the responsibilities associated with the position. The amount of time needed and the quality and quantity of work will likely vary from week to week and are not the basis for payment. Employers certainly benefit when salaried, exempt employees put in long hours for no extra pay. If employees are not paid on a salary basis, they are not exempt from the FLSA's requirement, regardless of how obviously executive, administrative, or professional their job duties. This approach to determining whether employees are paid on a salary basis is known as the DOL's pay docking rule. Under the pay docking rule, exempt employees must receive predetermined amounts of pay not subject to reduction due to variations in the quantity or quality of their work. Employers cannot reduce pay for partial day absences for personal reasons, for time missed due to jury duty or temporary military leave, or for temporary business closings when the employee would be able to work. However, exempt status is not jeopardized by deductions for absences of a day or more for personal reasons, for absences due to sickness, for unpaid disciplinary suspensions, or for periods of unpaid leave under the FMLA. To be clear, the pay docking rule does not make it illegal for an employer to dock the pay of a salaried employee, but if they do, the employees may no longer be considered exempt because they are not paid a genuine salary. A group of otherwise exempt white-collar employees was found not to be exempt because their employer made deductions from their base salary. Employers should be careful not to dock the pay of exempt executive, administrative, or professional employees for lack of available work to perform, partial day absences for personal reasons, and for time spent on jury duty. Employers should establish and communicate clear policies prohibiting improper deductions from the pay of exempt employees and providing a mechanism for handling complaints about any such deduction. Employees who are nonetheless subjected to improper deductions should be properly reimbursed. Most states have their own wage and hour laws. The FLSA permits states to establish minimum wages higher than the federal minimum wage. 29 states plus the District of Columbia had minimum wages higher than the federal minimum wage in 2017. 4 had minimum wages lower than the federal minimum, but those applied only to small firms not covered by the FLSA, generally companies with revenues less than $500,000 per year. Minimum wage laws in a number of states have the interesting feature that, unlike the federal minimum wage, their minimum wage is adjusted annually with changes to the cost of living. State laws also frequently require higher payments to tipped employees. Thus, state wage and hour laws define minimum pay levels for a large part of the U.S. workforce. State wage laws are also important because they serve as a basis for suits to recover unpaid wages and establish requirements for when wages, including final paychecks, must be paid. Employers incur additional legal obligations to their employees, like affirmative action, when they contract to provide goods or services to the government. By Executive Order 13658, the minimum wage for employees of federal contractors and subcontractors is considerably higher than that specified in the FLSA. In 2018, it was $10.35 per hour. Other federal laws require payment of a prevailing wage for government contract work. These laws include the Davis-Bacon Act for construction contracts and the McNamara-O'Hara Service Contract Act for other types of service. The prevailing wage is the average wage paid to a class of employees in relevant geographic areas, an amount determined by the DOL. The inadequacy of the FLSA minimum wage has sparked campaigns for living wage laws. These laws mandate levels of hourly pay in excess of federal and state minimums. Many cities and counties have enacted living wage law. Employers must be aware that they might be required to pay a state minimum wage, prevailing wage, or living wage that exceeds the federal minimum wage. The FLSA provides employers with an economic incentive to minimize overtime work, but it does not directly limit the number of hours that employees can be required to work. Nor does the Act generally require that employers provide rest periods, breaks, or time for meals. though there are compelling safety, productivity, and labor relation reasons for doing so. With the exception of regulations pertaining to particular groups, such as airline pilots and truck drivers, federal law is largely silent on this matter. At least 21 states, however, mandate breaks or meal periods, and some are quite specific about their timing. A large number of states required mandatory rest periods for minors. Although the FLSA does not generally limit hours worked, it does prohibit oppressive child labor. This requirement affects hours of work for minors. The federal minimum age for employment is 16. However, to perform certain hazardous occupations like mining, logging, roofing, using power-driven meat slicers, employees must be at least 18 years of age. Minors, 14 to 15 years old, can be employed in certain service or retail occupations subject to restrictions to their hours of work. When school is in session, minors must be employed outside of school hours between 7 a.m. and 7 p.m., not more than 3 hours per day, and not more than 18 hours per week. When school is not in session, minors can work up to 8 hours in a day and 40 hours in a week. In the summer, the workday of minors can be extended to 9 p.m. To comply with the FLSA's child labor requirements, employers must ascertain the ages of their youthful employees. Doing so, even in a pre-employment context, does not violate the Age Discrimination in Employment Act because the protected class is employees 40 years of age and older. Undoubtedly, in many cases, the FLSA's hours limitations for minors are winked at by employers and employees alike, but there is evidence that excessive work hours can harm teens, like with lower grades and greater alcohol use. No matter how complicit minors are in violating the law, it's the employers who are legally responsible for compliance. Pay disparities, based on any protected class characteristics, are discriminatory, but pay discrimination based on sex is a particular concern. A substantial gap still exists between the earnings of full-time male workers and that of full-time female workers. Overall, female workers had median weekly earnings that were 82% of men's corresponding earnings in 2016. Many factors undoubtedly account for the persistent male-female earnings gap. Identifying discrimination in pay is particularly challenging. Pay determinations are, by their nature, individualized. This is particularly true when an employer bases pay on assessments of individuals' performance or merit. Pay is influenced by a multitude of factors, including the labor market, an organization's pay structure, the conditions and demands of the job, and a host of individual characteristics like seniority, education, or special skills. More than most other employment decisions, pay determinations are subject to negotiation and are affected by prior decisions that might reach back far in time. Sorting through these complexities requires an approach somewhat different from that used in other discrimination cases. A methodology for proving pay discrimination has been developed for Equal Pay Act cases. Employers are prohibited from paying a person of one sex at a lower rate than a person of another sex for performing substantially equal work in the same establishment. Proving pay discrimination first involves finding a comparator, one or more people of the opposite sex who are paid more for performing the same type of work as the plaintiff. Importantly, comparators are usually limited to people employed in the same establishment. Pay comparisons across companies or even among personnel in different divisions, offices, or plants of the same company usually will not suffice. Equal Pay Act cases often hinge on whether the plaintiff can show that she and the comparator performed substantially equal work. The two jobs do not have to be identical or carry the same job title, however. The duties and tasks performed as part of the two jobs must overlap substantially. At this point, the Equal Pay Act incorporates the logic of job evaluation. Job evaluation is a systematic process for rating jobs in terms of certain compensable factors. The requirements of jobs, rather than the performance of individuals, are the basis of job evaluations. Jobs that are rated higher are more demanding and valuable to employers and tend to be paid more. The Equal Pay Act cites 4 compensable factors to be used in determining whether jobs are substantially equal. skill, effort, responsibility, and working conditions. Skill refers to what one needs to know to be able to perform the job. Effort is the amount of physical and mental exertion required by the job. Responsibility refers to such things as accountability for outcomes, supervisory duties, and involvement in important decisions. Working conditions under the Equal Pay Act refers to hazards, how dangerous the job is in terms of physical demands, and surroundings, elements such as fumes or outside work in cold weather. For jobs to be substantially equal, there must be a significant commonality in duties, levels of required skill, effort and responsibility, and of working conditions. As in other discrimination cases, a prima facie case suggests that pay discrimination might have occurred but does not resolve the matter. The employer in Equal Pay Act cases can justify the differential in pay as being due to a seniority system, a merit pay system, a piece rate system, or any other factor than sex. Factors other than sex might justify pay differentials for equal work, including differences in educational attainment, experience levels or training, shift premiums, and different rates for full and part-time workers. Some justifications raise more questions than others. For example, to the extent that women receive lower pay in the labor market, using prior salary level as a basis for others tends to perpetuate this problem. Some courts maintain that any other factor than sex will suffice to defend a pay discrimination claim, even factors that lack any apparent business rationale. Under this view, basing pay on prior salary level is lawful despite its potential discriminatory effect, unless the plaintiff can show that the prior salary was in fact the product of sex discrimination. More often, courts have held that employers bear the burden under the Equal Pay Act of proving that a factor other than sex serves a legitimate business purpose. Women may also be disadvantaged because some evidence indicates that women are reluctant to initiate salary negotiations and to drive a hard bargain, particularly in the absence of confirmation that pay is negotiable. The claim that a particular employee was paid more because he demanded a higher rate of pay in negotiations with the employer could easily serve as a pretext for discriminatory pay decisions. Employers justifying differential pay on the basis of individual salary negotiations should be able to point out abilities or experience that justify acceptance of demands for higher pay. Differences in the revenues or profits accounted for by positions have also been advanced as a factor other than sex, or as a basis for finding unequal work. Employers making this claim should ensure that the more lucrative positions are open to both male and female employees, and that the differential profitability in itself is not a product of discrimination. In short, employers should be prepared to account for pay decisions, particularly when males and females performing similar jobs in the same workplace are paid differently. Defending pay decisions is much easier if employees establish and consistently apply specific job-related criteria for making those decisions. Employers should avoid basing pay decisions on the pay level in a prior position or on demands made in negotiations unless these actually reflect the abilities of the individuals in question. Finally, if pay discrimination exists, it must be remedied by raising the pay of the lower paid individual. There is a consensus that use of prior salary as a factor other than sex under the Equal Pay Act tends to disadvantage women given their generally lower pay. A number of cities and states have recently enacted or are in the process of enacting bans on employers asking job candidates about their salary history or using salary history as a basis for compensation offers. The San Francisco statute, which became effective in July 2018, bans both salary history inquiries and employer reliance on prior salary as a factor in employment or pay offers. Additionally, employers are prohibited from disclosing an employee's past salary to prospective new employers without the employee's written authorization, unless the information is publicly available. The statute permits job candidates to voluntarily disclose prior salary information as part of pay negotiations after an initial offer has been made by the employer. Pay secrecy policies discourage employees from sharing information about their pay and sometimes require the termination of employees who violate the policy. Informal practices of discouraging discussion of pay among coworkers appears to be common. A recent study found that 61% of private sector respondents were subject to such pressure. Whether the advantages of these policies, they clearly pose obstacles to employees seeking to determine whether they are victims of pay discrimination. They also interfere with employees' rights under the National Labor Relations Act to join together and communicate about workplace concerns. Thus, employers should refrain from establishing and enforcing pay secrecy policies.